All right. So, good evening. I'm Denise Tessier, and I'm pleased to announce the grand opening, finally, for the Tessier Law Firm. Our law firm's mission is to empower our clients to really take charge of life's most challenging transitions. We're just starting to get integrated into our Polk County community, from Lakeland to Winter Haven and Lake Wales, and we'll be providing a number of important educational workshops in the area and beyond. So this presentation today that you've been invited to is a friends and family session, the purpose of which is to really help me try out the tools like polls in Zoom and how the registrations work. So hopefully that's been fairly smooth. And we'll be sending you a very brief survey after the seminar so that we can get feedback on the presentation and make sure that everybody's comfortable with the content before I go public. Now, before we start, let me introduce myself because I have some folks on that may have gotten this actual link through other people. Now, not everybody knows this either, even from my friends and family, but really one of the reasons that I'm so passionate about this practice area and getting integrated into our community with estate planning is based on an experience that I had with my friend Tara. And some of you know Tara. She's a very sweet woman, and she is so strong for all of her friends and family. But she called me about 2 years ago, just about 2 years, to tell me that her mother-in-law had passed here in Florida. And she and her husband, Tom, were just beside themselves. Aside from the grief and the shock at having such a surprise death, they were really worried because they didn't know if she had a will, if she had a trust, if she had any documents at all that would help them through the process of handling her estate. She had a house to sell, and they were just very concerned about what steps that they had to take, anxious and worried. And they were worried for themselves because they could only come down to Florida for a short amount of time and didn't know how much they would be able to get done. So she was a hot mess when she called me, and she won't mind me saying that. And I really wanted to help. So I went out there, and in the space of the day, I was able to get together a plan for her to move forward with her estate administration. We took care of everything in the house and got things in piles. We got resources for her to go to donate things to charity and to sort out clothes. More importantly, we were able to go through mounds of old paperwork and find the will, a safety deposit box, and even some insurance policies that they didn't know she had. We were able to get into her computer and get a list of creditors. I ran her mother-in-law's credit report, so we knew what her assets and debts were right away. And this was super helpful during a very stressful time. At the end of the day, her personality kind of totally changed, and Tara felt much more relaxed about the process. And I knew that she was going back to Massachusetts with a plan in place that would carry her through the next couple of weeks. So, she was so grateful that it really meant a lot to me because I had been a corporate attorney for many, many years. And, it's a thankless job, even with raises and promotions and additional education. You never really feel like you're really helping somebody. And that's really the reason that I went to law school, to do something meaningful. So now, I have to get this cute picture of my mom and I'm in Disney here somewhere, and it makes sense to have it here because, I could really see myself in Tara's shoes. Her mother-in-law was actually very similar to my own mother in many ways because they had the same size clothes, the same style of dressing, the same way they decorated their house. And it made me really feel protective of my mom and worry about, what's going to happen when she goes, what happened, to my aunt when she's in a pickle and she has a lot of health issues. And really, a lot of my clients here in Florida and my friends and neighbors in my 55 and older community are just like them. So, again, I really wanted to be able to make a difference. And Tara would joke, you should be doing elder law and estate planning for a living. You live in Florida. And I did, so when my last job at IBM was eliminated due to COVID and massive restructuring, I took advantage and immediately registered for the Florida bar exam and have been studying for thousands of hours, literally, over last year to really get up to speed on estate planning and elder law to come out full guns. Now, when I started the journey, I knew estate planning was going to be pretty complex. It's, a new area of the law is always hard to get over the hump and make sure that you know everything so that you could serve your clients with the best interests. But it's impossible to keep up on everything on your own. You really have to have powerful help at your fingertips and educational resources and people with experience that can guide you. So I was very fortunate to be invited into the Academy, the American Academy of Estate Planning Attorneys. This organization is devoted to providing the highest quality estate planning education and services through over 400 member firms throughout the United States. My firm is only one of 7 in Florida that qualify for AEPA benefits and services, and membership in the Academy has given me a network of over 1,000 dedicated attorneys that are just doing estate planning, elder law, and Medicaid planning, as well as trust administration. So if I can't answer your questions, I got a guy or a girl that can certainly help. And it's a real benefit to everybody here in Florida that's moved in from other states. Now, I'm also admitted in Massachusetts and Connecticut and can still practice in those areas. So to the extent that you need help on those estates as well, we can do it by Zoom like everybody else in the world now. And certainly would willing to help you. A lot of the seminar here is geared towards Florida law, but there will be a lot of general principles that will apply up north. Just a little bit about the Academy and Money Magazine. It's been recommended by their magazine for several years, and anybody that knows Susie Orman, she's my guru. She's really the national resource for how to manage your finances. She's been recommending the American Academy for years as well. So it's a very solid organization. And when I talk about when I go through this presentation, I'm representing not only myself and my firm and the team that I have now and the team that I'm going to be building up over the year, but the background of the Academy attorneys that are providing me the benefits of having a big law practice as a solo. So our goal today is to learn about wills, trusts, and medical directives, particularly in Florida, and really to teach you how that you can take charge of your life transitions as you go through various life stages. It's geared as basic information. Whoops. Plan for the fire truck. This is geared as basic education for those who haven't started any estate planning. But if you have wills or trusts and you want to know more about them or why they work because it was never explained to you, we'll go through that tour. At the end of the presentation, I'll tell you how an attendee can receive a free personalized consultation up to 90 minutes, valued at $450 just for attending the seminar. I don't do normally free consultations at 15 minutes or 30 minutes because it's just not enough time to really get into your issues and really look at what you might need for your estate plan. So we've done it this way, where if you attend the seminar, you get the learnings, it actually cuts down on the number of basic questions that you have, and we can really dig right in on day one. So the seminar will cover what's a will and why you need one, what's a trust and why you need one, and that'll be in the second half of the presentation. We'll talk about legacy wealth planning, which is a comprehensive and holistic view of estate planning, as well as how to get started and what the average cost and fees would be and the expectations as to the planning process. So I'm going to launch another poll because I really like these polls. Wanted to know, what do you think would happen if something happened to you? If you end up getting hit by a bus tomorrow, what would happen to you? It's a multiple choice question, but really you probably just need to pick one. First, I don't know what would happen. Or everybody might say that I'm going to pass it over to my spouse who would decide on how to pass down the legacy. Maybe you have a will and that's fine. And so that's in place, you can check that. Or maybe your child's name's on your assets and you're thinking that, well, I'll just go to my kid. But this kind of information is helpful to know if you guys have access to the poll. Give it a shot here and it'll give me a little background as to how to treat the next couple of questions. We'll give it another about 30 seconds so that you guys have a minute to really think about it and answer, appropriately. And of course, I'm already saying that there are a few of you that are saying, I know my estate would be a hot mess, and that's certainly understandable. Usually estate planning is the last thing that people want to do, particularly on a nice day or when they've got other things in their life that are going on and their priorities. But, as we know, it's something that needs to be here, and I congratulate you for getting started. So I'm going to end the polling right now. Thank you very much. I can see that a lot of you have said that I would pass everything on to my spouse, who would then decide on how to pass on the legacy and the assets. So this is interesting. I wonder if your spouse knows that, that they have that responsibility. And we'll talk a little bit about, why that's difficult, because what happens if your spouse is disabled or something happens to them before you do. So I am going to get out of my poll, and I am now going to share my screen again, screen 2. It's getting used to this, so there we are again. All right, that worked, yay. Okay, so, but let's just talk about why I asked about that, because these are really scary times in America. Whether you're a senior or a retiree or a younger person in relatively good health, even aside from COVID, there are significant legal and medical trends developing that are likely to touch every one of us in profound ways. Research shows that over 16 million lawsuits are filed in state courts every year, and almost 750,000 people petition for bankruptcy. That's going to go way up in the next couple of years too, with people that are unemployed. But really, an estimated 1 out of 4 bankruptcies are due to overwhelming medical bills, and many are filed by people of all ages. It's not just nursing home expenses, it can be accident expenses and other kinds of debts that are driving folks into bankruptcy. And let's not forget about the breakup of marriages. That's always a concern. It's no secret that our divorce rate is one of the highest in the world here in America. And that really means that it's the exception now that people have like their own kids and not stepkids. Most families in America are blended families in some way, being a product of remarriages and partners that have separated. And what happens if you get older and need some assistance? Expenses for healthcare are still rising phenomenally every year, and elder care is a top concern for many individuals and families. In Florida, the average nursing home or assisted living facility costs vary widely based on quality and location, running right now between $3,500 and $7,000 a month, or over $50,000 to $80,000 a year. In Massachusetts and Connecticut, statewide averages are almost double that because there just aren't enough nursing homes, and a lot of them are, really intensive care or memory care units that are more expensive. The average cost just in general is over $100,000 for a whole stay of about 18 months for most people. Furthermore, there's over 53 million Americans that regularly provide care for their parents or elders that are limited in their physical activities. A lot of the sandwich generation are not only raising kids, but they're taking care of mothers and aunts and other family members. And that's something to really be aware of in estate planning nowadays, because you're not just supporting your kids financially if something happens to you. You might be supporting other family members who are reliant on you for home care or checking in on medical issues. And you might have a financial and a physical responsibility to them. So if you're disabled or you're in the hospital, somebody else has got to fill in for that. And that might be part of your estate itself if you want to be able to provide some comfort for that person out of your own finances. Now, I shouldn't even mention it because everybody's hearing it every day, but I do have to say CNN reported yesterday that we're over 500,000 COVID deaths, and that doesn't even tell the whole story because of the number of people that have been hospitalized, could be hospitalized, and we're all very aware of that. But one of the most serious issues we face is always emergency hospitalization, because there's tons of accidents, in addition to long-term illnesses and things like dementia and Alzheimer's, which are touching more and more of us every year. So powers of attorney and healthcare proxies and your directives or medical services are just as much of a comprehensive estate plan as wills and trusts. You can't think of estate planning anymore just as about the money. So I do have to tell you though, most families do come to attorneys after a death, have nothing in place to tell the world what they wanted for their money and possessions or their families. With the free online documents nowadays and do-it-yourself wills, you think people would have these, but they're very confusing and they're not drafted well. And a lot of them are totally invalid if you don't have them signed properly, or you don't have them funded. If you have a living trust, they need to be funded as well. And that really takes experienced attorney help. Many lawsuits are being filed over cheap wills and trusts, and it just creates more probate litigation when there's disputes about unclear terms with the family. The sad fact is that litigation's expensive, but with a little planning, people could have prevented it. Now, who comes to your mind when we talk about these trends? All of us have experienced situations where family members or friends have been seriously injured or now live with ongoing medical issues. We have been surprised by friends and family who have died too young, and I know everybody will think of somebody when I say that. Or we might have had our own major health scare. Many of us have also had serious financial scares, perhaps losing a job or having other financial difficulties, and they're worried about, how their spouse might fare when they pass if it's not in control of their finances overall. Imagine what this could happen to you. But clients always kind of say the same thing. It's like, well, I know all these other people are sick and, people can die, but I never thought it could happen to me. And that's really kind of the sad thing. But what might keep you up at night? Clients tell us they have 6 major concerns when they think about planning for the future. For many, they want to make sure to pass on their hard-earned wealth without the government or the state or the courts being involved. They really don't want somebody else to make the decisions, whether or not it's another family member or an outside guardian or a judge. We'll talk about more of this later. Next, they want to avoid any unnecessary taxes and fees. While the current federal estate tax exemption is quite high, it's about $11.7 million, the rules change frequently and may not be the same when somebody passes away. Right now, that $11.7 million exemption is going to drop in 2025 to $5 million, and it could go way down, especially as the government needs its money to pay for all the COVID expenses that it's incurring now. Someday it's got to be paid back, and having a high estate tax and a lower tax exemption could be a real issue that you have to consider in your own planning, looking 5, 10, or 20 years ahead. Families are also surprised when they try to give their house as a gift to their kids or name them on the deed instead of doing prior estate planning, because they don't realize it can trigger gift taxes or additional income taxes for the kids. So we'll talk a little bit about that later. But most importantly, people don't want to pay unnecessary legal expense for administering their estate and probate if there was a way to avoid it totally when they were still alive. They don't want their families to be in Tara and Tom situation where it's a 6 to 12 month process at a minimum to go through probate before you can sell the house, before you can sell the car, etc. They want to really make sure that any wealth they pass down is going to actually go to the kids. And courts are incredibly backed up right now with having to do everything by Zoom. So even that probate process can be longer. It can take many years, and particularly if there's a dispute amongst the family. So the number 4 concern might even be a number 1 concern for many people. They want dignity in their final years, and they want to avoid going broke paying for nursing home costs or other crushing medical expenses. Will you have enough money, family support, or other resources to be able to stay in your home as long as you would like? Can you protect your money now so that when you need it for care or your spouse's care, you can get the quality of care that you want and not just let your money run out and then be stuck with whatever government assisted living or nursing home that you get put in? For example, it might mean the difference between having a private independent room versus having a roommate after living alone for 50 years. There are ways that you can prevent your family's money eaten up by medical expenses and Medicaid planning specifically that you can do so that you can preserve your assets for your family and potentially your spouse while still being able to get your government benefits. And we're not going to get into that too much today, but it is something that is part of your holistic and comprehensive estate plan. Further, people want to make sure their family is protected from predators and creditors once they've passed on, and we'll talk a bit more about that. Perhaps most important of all, once they're gone, they want to make sure that the family is not torn apart over money and possessions, because you'd be surprised, or maybe you wouldn't, about how people fight over just the stupidest things. Oh, mom promised this to me, or mom said that she was going to give me this, and the kids worry that they're not getting equal shares, and it just gets to be crazy. So if you're able to create a plan early on and have the discussion with kids as to what they're getting, might cause a little bad feeling now, but they're not fighting amongst each other, and they know your wishes and the reasons why you're making the decisions that you are. Really, a third party can help those tough conversations happen. The number 1 concern that many people have, and maybe you're surprised by this, but they want to be remembered. They want to make sure that their memories and shared experiences are passed on and they're not just some photo in a scrapbook. And, proper estate planning is a tool for that. And what we do in our legacy wealth planning program is we actually provide some extra tools to allow you to record your legacy, whether on paper or in video, and we really work with you to be able to enable you to do that. Now, some of you might have these same concerns. I'm going to stop sharing and I'm going to launch a poll. What a surprise. I like my polls. But seriously, what major concerns are the most important to you? And maybe you've never thought about this. For you, maybe it's government and you want to make sure you're in control, or maybe it's not having any creditors or predators. Let's give it a shot. I'm going to give it 1 minute to let you take the poll, and I promise this will be the last one. But this is sort of, how people now keep interactive when you have to do Zoom presentations instead of being in public and having the ability to feed people cookies and cocktails. You get a Zoom poll, so hope it's a little exciting, but it makes you think and it makes you put yourself in the shoes of others at this point. We're getting some responses. And just as compared to the seminar that I did this morning, we have a lot more people at nighttime that don't want the government involved in their business. We also have a lot of people that are concerned about planning for nursing home costs, which is totally, understandable in this day and age. Even if you are a little bit younger, you might have concerns for your parents or your family. All right, thanks. I'm going to end the polling now. And we also had a lot of people that didn't want their family fighting over money or things. So I guess that's a biggie for everybody. And a lot of us have probably gone through this. So our goal is to make sure you have the information to ensure none of these life-wrenching events happen to you or your family. But, is knowing enough? A lot of us want to lose a few pounds, and knowing that you need to diet and exercise is different than actually taking action to diet and exercise. And don't I know that? So we really want to make sure that once we've gone through the education today, if you're thinking that you need to take action, you do, and we'll make sure that you have the steps to be able to do that. We really want to congratulate you on participating in the session and making the first step to get going with whatever plan is appropriate for your family. What is the reason that people don't plan though? Number one reason is, not surprisingly, simple procrastination. Perhaps you have a will that's been a long time since it's been reviewed or updated, or perhaps you have never actually started a will. Maybe you need a guardian for your children, but you've never named it, which is an issue because not only will that guardian need to make medical decisions and financial decisions if something happens to you, but children can't inherit money. So, you need to have a vehicle for enabling them to have your inheritance managed properly. It might not be their parent if you've been divorced from their parent from someone. You can think about these things periodically, particularly during COVID times, and there's a constant niggle in your brain, but maybe, you haven't taken the first step, and that's okay. But, we don't want to procrastinate for too long, and too many people just let things go and then something bad happens. And that leads us to the number two reason that people don't plan is lack of knowledge and learning. Clients often come in confusion, whether or not they have a will or a trust. They've heard about so many changes in the law and they know that they need to do something, but the documents that they have, they don't really understand, and they don't know whether or not they've got everything in place to protect their family, or maybe their family situation's changed and they know that their documents are no longer valid, but they don't know what to do about it. So our job today is to make sure that you understand what the current thinking is on the strategy for financial planning and making sure that you know that you'll need to update that over the years. It's not just a one-time exercise, it's an ongoing exercise for all stages of life. Now, the number three reason might not be something that springs to mind immediately, but many people think they don't need to do estate planning because they feel they don't have enough money to make it worthwhile, or they believe assets that will be distributed automatically by the law or by their family would be the way that they wanted it to be. The traditional way most estate planning has been done in America is pretty narrow and really does focus on money and assets and avoiding taxes. But nowadays, as we started talking, you realize you need medical directives. You may need to be able to give your children additional protection in the event that there's marriages or divorces. And we'll talk today about some of the other reasons why money is not the only issue when you're estate planning, and you really need to have a comprehensive plan. Because most of all, what's important to you, it really is your health, your family, your friends, your values and your skills, and those human relationships and shared experiences that you're going to pass on. We want to add into estate planning accumulated wisdom, lessons of life, and the experiences that you've had that you want to pass on to future generations, so that maybe your kids know you, but maybe your grandkids don't. Don't you wish that you asked your grandparents or great grandparents about their life? We'll help you do that. Our true values, our core values, our wisdom, our dedication to the community, that all is part of who we are, what we want for our family, and what direction our estate planning will take. So estate planning is not a one size fits all. You can accommodate a lot of your wishes and your family values into your plan by choosing appropriate protections, whether or not it be special asset trust, century trust, and other things that we'll be talking about today. It really brings the estate planning process into a bigger realm. Because most estate plans fail that have been written years ago because they're core documents. They only cover certain tax situations which have changed over the years, and the strategies are now inappropriate. A lot of times there's no nursing home protection, and the trust, no matter how much you pay for it or who's drafted it, is worth nothing if you haven't funded it with assets and actually moved your assets into the trust. And we'll talk about that, because that's a big mistake. A lot of attorneys just used to not deal with funding and let the client do it, and it never got done. And so the trusts were never funded and never really helped the family. So getting things online or getting things from folks that are not experienced in estate planning is not good. And we consider these fast food documents, and they don't really work. So we're going to talk about what a good plan should look like, no matter where you do it and how you do it. To help you understand the issues that confront families in estate planning, I'm going to tell you a little story. We're going to introduce you to a married couple, Bill and Mary Jones. They've been married for a long time and live right here in Polk County. After moving here from Massachusetts, they moved here 3 years ago to retire to an active adult community. They're typical of clients that I'll see today and concerns that they have, and they've worked all their lives and have an estate that they don't consider all that big. But when you consider its value for estate planning purposes, it's quite large. It's about $700,000 by the time that they include houses, investments, life insurance, and personal property. It's not unusual for their age to have that or even more. And, it's certainly growing as they continue to invest. Now, some of you might wonder, well, I'm still single and I've never been married, or I'm widowed or divorced. So will these kind of stories appeal to me or actually apply to me? And they certainly will. They're going to show you the principles of what we're talking about. So the two main reasons that Bill and Mary want to do a good job with their estate plan are their two children, John and Susan. Not only have Bill and Mary done a remarkable job at raising them and preserving an estate for themselves and their family, but they've built a life on a strong work ethic and really tried to pass down, family values. Like many families, each of their children, though, took a different path in life. Susan was the golden girl who always excelled at school, was responsible, and looked after her finances. She's a practicing CPA with two wonderful children that are, in their preschool years. John, on the other hand, was never quite conformed. He was a rebel as a child and continued that behavior on as an adult. He's had two marriages, he's never held a steady job, and it's clear that he's starting to get addicted to drugs. He lives still up in Massachusetts where pot is legal, and he's taking full advantage. So, his parents are starting to be very concerned about him and are worried what he'll do with his inheritance if he gets a big chunk of money. So, Bill and Mary haven't done anything quite yet in our story. Normally I'd launch a poll here to see if you have a will or a trust, see if you've kept up with the Joneses, but we'll skip that and move right on because I think we've done enough polls today. So instead, we'll look at Bill and Mary's estate planning options here and what they could do with their plan if they had one. Now, one of the first options is they could be spending every last dollar. You'll see a lot of bumper stickers on RVs that say, I'm spending my kids' inheritance. And, sounds like a good idea, kind of work it so that you're taking all of your money during your lifetime, but it doesn't really work that way. We never know how long we're going to live and if we're going to need the money. And it may be that, you'll live much longer than average and you're going to need it for long-term care or nursing homes. So you can't really spend it all as a tactic, even though people joke about it. Another strategy that people have is called dying intestate, and that means doing nothing and letting the state take care of it. Intestate's not a dirty word, but your family will call you dirty words if you die without any kind of plan, because in many cases, the state's allocation scheme for assets is not what you would want or match anything that relates to how families today are put together. It means that you've died without a will and no planning provisions, and you've given up the right for yourself to decide who gets your estate, what they'll do with it, and under what conditions. And you have no control over what tax laws have been passed. So you could incur a lot of, if not federal taxes, state taxes, gift taxes, and other types of things. So as an example, here's how it works in Florida. We're going to see this little couple here. That's my husband and I. We were both married before, and I have one daughter still in Massachusetts, and my husband has 2 kids in the UK. His daughter is currently with a partner, but no kids yet, and his son is married with 2 grandkids, and we consider them all our kids. My husband moved here when my daughter was 8, and even though she still has her dad locally, my husband now has raised Raina for let's see, 16 years now, and that's a big issue because the law does not reflect that. So what would happen is if we had a house, for example, and I died and the house was in joint names, it would go to Graham, and if Graham dies, the state says his heirs, his natural born heirs, get all of his assets. So all of the assets would go to his family. My daughter would get nothing. Similarly, if he died first and the house went to me, I could give the house to Raina, but I would have no obligation to give anything to his kids. And we certainly wouldn't want to do that. It creates bad feelings, and it's just not our wishes. So we have to do a will or a trust to make sure that the distribution is settled. And that happens all the time. People don't realize what the default is going to be. And that's similar in Massachusetts and Connecticut too. There's all kinds of crazy statutory provisions about who gets the money and where it goes if you don't decide. So the next way that an estate could be planned is by using a lot of joint tenancies. And what that is you have 2 people that own property will own property as joint tenants so that if one dies, the other automatically gets the property. Now, this sounds like a good idea, but it's really not an estate planning tactic for a number of reasons. And people should really understand this because a lot of times I hear in Florida here, people move from up north, they buy a house, they want to put their kid's name on the deed right away. And there's a lot of problems with that. They're really losing a lot of protection. First, it only delays probate. So it doesn't avoid probate. It just doesn't happen until the second person dies. And the problem is if both people die together, the property is still going into probate and incurring a lot of costs, which we'll discuss later. But you can also, unintentionally disinherit folks if you're only giving property that's in joint tenants. A lot of times people will say, okay, I'm going to give the house to my daughter, and so I'll put her on the deed, and when I pass, she'll get the house, and they're going to give IRAs or other resources to another child. But what happens if the house goes down in value, or the stocks go down in value disproportionately? Instead of having a pool of assets that can be distributed to children, doing specific gifts through joint tenancy ends up disadvantaging somebody somewhere along the line. There's a big risk that there will be very unequal gifts. Now, the big thing that people don't know is as soon as you put a property in joint tenancy with somebody that, is it like a child or not married to you, then that triggers gift taxes for them. So normally they don't have to report and don't have to pay taxes on gifts that are $14,000 or less. But say you have a house that's worth $200,000 and you put it in your name and you put it in your daughter's name. She gets 50% of the house now, and that's $85,000 more than the gift tax exclusion. So she may have to pay tax on the gift of the house equity of up to $85,000 immediately. And nobody really wants to do that. Plus, you lose the value of what they call a step up in basis. So if I give my daughter, half of the house now and put her name on the deed, and the house is worth $200,000, well, we're not going to sell it until maybe I pass away, 10, 15, 20, whatever years from now. Maybe the house will be worth double that, $400,000. And the basis in that is no longer $200,000, it's going to be $400,000. She'll have to pay tax on the difference of the $200,000 and $400,000 as capital gains tax, which is a big chunk of money. It's like 10%. She'll lose about $50,000, $40,000 to $50,000 on that, just because she was named on the deed early. So those are significant issues for everybody. But for my Florida and Massachusetts folks, danger number 6 is that you lose your homestead protection. Homestead is not just a tax benefit. You do a Homestead Act filing, or you claim homestead because you're living in your house is protected against a sale by creditors if you have debts and have liens against the house. They can't force you to sell. And that's really important when you have one spouse, for example, with a business or a lawsuit against them, or a nursing home that has debts, and that person, one spouse can't pay. They can put a lien on the house, but they can't force the sale and force you to move. But if you put your child on the lien, you're no longer claiming it as homestead, you're just tenants in common. And if your child has debts or you have debt, it is a possibility of a forced sale. So you're losing a lot of legal protection there that people don't realize could be a big factor when they're older. So another option, which is not a bad option, is the will. This is a legal document that names who will handle your estate, and it's a foundational document to identify where property will go and what kind of management that you'll want over your personal property, like your household goods and your car. But they're very common, but they don't solve every problem. They really can be problematic in themselves. On the pro side, they're a foundational document, and everybody should have at least a will instead of going intestate, because then you'll at least have your property distributed to your family. But it only provides some basic protection, and it it enables you to provide guardians for your kids, and it's relatively easy to prepare. More complex wills can sometimes establish testamentary trust to actually help you manage the distribution of money and goods over time, so you're not necessarily giving money to somebody in one lump sum. So a basic will with a testamentary trust that takes effect at death can do that, but in general, that's where the benefits end. The cons is that it has to be submitted to probate unless the estate is very small. For example, in Florida, it's under $75,000. I think in Massachusetts, $100,000. We'll talk about that later, and the severe cost of probate. And it only takes effect upon death, so it provides you no protection and no help with disabilities or emergencies during life. The property in multiple states require multiple probates, even if there's one will that says who gets what. So if you have a vacation home, or you've got still a house in one state and you've moved to Florida and you're keeping it to go back and forth, you're going to double all of your time and expense, even if you have a will. It doesn't do anything for that. And it cannot be handwritten. So in any state, know that. I know, I think my mother tried to write a will one time, and it has to be formally notarized and witnessed, or else it's invalid. And then you're back to the intestate process and the court won't enforce it. The next options we're going to discuss today is the trusts. And there are two types. There's my Clark Kent Bare Bones Trust, which is, just the bare bone basics to be able to keep you from going into probate, but it only addresses, maybe your money, your finances, and some tax issues, and isn't going to handle all of the issues that we're going to talk about, like we would have with a family wealth trust, where you can really have significant protection both for death and for life to preserve your assets, and also so your other decisions around medical and healthcare options. The family wealth trust is really what we have as the superpowers trust. So back to Bill and Mary. Like most people, Bill and Mary have busy lives with hectic schedules. When they were planning to retire to Florida, they had good intentions and they made a list. They're going to move to Florida, check, exercise, plan vacations, review their finances, because they do that once a year, and they're going to volunteer. And then down at the bottom, they thought, well, we'll create a will and have some prepaid funeral arrangements, so we know that's settled. And, they were getting around to it. As soon as he moved, though, Bill was anxious to start playing pickleball in his new community. And before doing anything else, including consulting his doctor, he launched himself into vigorous activity and joined a league and played several times a week. So you might be able to guess what happened next. He had a mild stroke. After a 3-day stay in the hospital, he got the okay to go home, but he was quite alarmed by the whole experience, and Mary was freaked out. She's like, why'd you do that? We don't have any documents in place, and I couldn't, speak on your behalf because I don't have my medical directives. Maybe she had a hard time getting his medical records because she didn't have the HIPAA releases while he was, disabled for a few days. So the first person they called was a local real estate attorney friend who was on the pickleball team. And Bill told the attorney that, should he pass away first, he wants everything to go to Mary. And Mary says, yeah, and when I pass, everything goes to Bill. And they just left it at that. When they were both gone, they agreed that children should receive, everything in equal shares, to be fair. And after admitting he wasn't an expert in this area, the attorney agreed to do the will. And when he was done, he had everybody sign everything properly. And they thought they were done. They thought they were all set, and they didn't think about any other issues they could possibly have. And the attorney didn't really know either what could come up. And this has actually happened to me. I was involved in a probate litigation with some of my, my father's former family, because he had his real estate attorney fill out his will, and there were some provisions that were ambiguous. And we were really worried for a while that my mom was going to get kicked out of her house because, this litigation was going on, and my half sisters were trying to kick my mom out of the house. We ended up settling it, but it does happen. It's a real thing when you don't use experts. But anyway, so back to Bill and Mary. So they congratulated themselves and, were fine for a few weeks, but then something else happened to Bill. And it's not that he died. I mean, the biggest risk for most people is not death. It's actually becoming disabled and being able to take care of yourself or being mentally incapacitated. After his minor stroke, he had a major incident and he was unable to handle many of the tasks of daily living. So at this point, he's categorized as somebody who needs long-term care. Now, there's a lot of confusion about long-term care, but it includes medical and non-medical care for people who have a chronic illness or disability, not a short-term problem like an accident or an illness that will be soon over, and healthcare insurance will pay for that. But most long-term care is to help people with the long-term physical activities like going to the bathroom and bathing, and it needs to be provided generally in an adult daycare, assisted living, or in nursing homes. And if you've got Alzheimer or dementia, in memory care units that are incredibly expensive and hard to get into. You can really need long-term care at any age because you don't know when you're going to be disabled, or you may never need it at all. But 70% of people over 65 are going to need long-term care at some time. And by 2050, it's projected that 27 million Americans, or 10% of the population, will be in long-term care. Up to 80% might even be at home with unpaid caregivers, usually family members who become dependent on financially, emotionally, and physically. So, that's something to really be concerned about for any age, even though it's more pressing as you get older. It's always there. There are only 5 ways to pay for long-term care expenses. So, you can pay for it all yourself if you've got savings. And at $100,000 a year, then it can quickly bankrupt you depending on how long that you're in. Certainly, if the average is 18 months, a lot of people are in a lot longer. And, for Bill and Mary, it's something that they are very fortunate to have the $700,000 that they have, but it's going to cut into what's available for a spouse if one of them dies. Now, if you planned wisely and purchased long-term care insurance when you were young and healthy, you could use that to cover the expenses, but really only fewer than 2% of the people have long-term care insurance, and it's becoming increasingly more difficult to find because, the companies that were starting to write that are saying, hey, it's more expensive to administer with all the costs going up so fast. We didn't really plan for that. And with the investment rates going down, it's hard for them to make money. So, you're lucky if you have it. Now, Medicare is not a safety net as most people think it is. It's a federal health insurance program for those age 65 and over, but offers limited benefits for those needing long-term care, and it won't pay for chronic illnesses that impact the activities of daily life. It's really not as flexible as you would think it is for many cares. And if you're older and have gone through any Medicare issue, you know what I'm talking about. So what's left? Medicaid. It's the government's medical welfare program that's a state and federal combination that pays for about 50% of the nursing home costs of Americans. It's really only those steps in when most of a person's wealth has been depleted and spent. You have to spend down all of your own money before Medicaid kicks in and you qualify for benefits. It's means tested and, very hard to qualify for if you've got any kind of assets. So, Bill and Mary, if they're looking at nursing home care for Bill, are going to be worried that there's going to be nothing left to give to their children. And it is, involves a lot of complicated forms and processes and can take a long time to go into effect before coverage is there. So, and again, it accelerates the amount that is spent from your pot of money. And there are ways to be able to manage your finances so that you could give something to your kids, provided that you are 5 years or more before you go into Medicare. And we're not going to get into Medicaid planning in this seminar, but that will be a subject of a later seminar, is how you can potentially protect some of your assets from the extreme high cost of Medicaid. If you're a veteran, finally, you may qualify for some veterans benefits, but there's, few and far between the vets now that will qualify for those. And a lot of times there's ambiguity as to whether or not a spouse can qualify, particularly if the people have only been married a short time, or, you could have been married to a vet for 70 years and then you get divorced in your later years and you don't qualify for any VA care. So it is very limited, but if you qualify for that, that's something that should be included in your plan. So, Bill and Mary's joint wills don't address any of these issues or help them pay for Bill's disability. Another question is, who's going to actually physically handle Bill's affairs now that he's disabled? If Bill has problems with cognitive abilities and can't handle decision-making and checkbook writing, etc., then a guardian or conservator may have to be appointed. A wife is not automatically qualified to do this for her husband, and a court will decide, will it be Mary or one of the kids? And Bill has no say in this because he's in the hospital and he's, not able to speak for himself, perhaps. It could be any of these people. And so you really want to make sure that you're avoiding what we call living probate, where a guardian has to be appointed. If Mary goes to court, living probate can be a nightmare. It's humiliating because people know that you're being brought in to be deemed incapacitated, and it's all public. So people can actually look at the court records and, see that that's happening. So it makes you exposed to creditors and predators because particularly a lot of scammers now will look to see who's been a judge incapacitated, and they might call up the personal representative that stepped in to take over the guardianship and try to sell them products that aren't needed, or, tell them that debts are owed when they weren't, and just mess with people. And the court's in control as well. It's time consuming, particularly now where everything's done on Zoom, and a lot of personal information is disclosed. You have to file in the guardianship papers exactly what happened and everything you can't do for yourself. So it's just not nice. And it's something that you want to avoid. And the average guardianship now is going to be at least $5,000 to $10,000, to an attorney to handle, just to get the right to take care of somebody. When they finally get through the living probate process, Mary does take over management of their household finances. But unfortunately, it's only over a year later that Bill passes away. At this point, Mary has to go back to court and now is confronted with the death probate process. So a lot of people are confused about death probate and why it's even needed. Basically, the probate's main purpose at death is to change title on the property that you own. If you pass away and your family wants to spend or sell an asset or refinance or lease an asset that's in your name, they can't do it until the title's cleared into their name and that, a title check will pass, that everything was done on the up and up, and the will was, if that was by will, was valid. And it's something that it's a protection for people that a court is overseeing this, but it's also a pain in the butt. The court will resolve any disputes among family members if there's some. The court will make sure that creditors are paid before they allow any distributions to be made. And there's a full inventory of assets owned, and appraisal of each asset is going to be required. Finally, after all that, a distribution is made to just the rightful beneficiaries. So probate takes care of inventorying, appraising, and distributing your assets to the rightful heirs. But again, it can be expensive and time consuming. It can take years to complete. And in Tara and Tom's case, they got away with a very quick probate. I think it was 9 months before they were able to sell their mom's house here in Florida, because it was pretty clear that the will was valid and it was pretty smooth. But that's not always the case, particularly when you have any kind of issue about the value of the house or who's going to inherit it. But it's open to the public, and there can be multiple probates if you have property in different areas. And again, creditors can know that somebody has been filing a probate case, somebody's died, and they can contact the heirs, trying to either sell them things or defraud them in various ways. For example, you can have a fake company that does title changes, writing to the family saying, hey, you have to pay extra to get this filed with your state court, and they look really legal, but they're not. And all of that comes from the fact that all these procedures are public and people can get to it. But in particular, for my Floridians, listen up. In Florida, it's mandatory to hire a probate lawyer in order to go through probate. You can't just have a family member do it. If you die intestate, and if you have a will, you still have to hire a lawyer. And there's certain kind of property that's exempt from that. I mean, it's exempt for small estates, but pretty much everything goes through probate here. And the fees for the attorneys are set by statute, so they're pretty high. It's one of the few states that set out what is reasonable for attorney to charge. And you can see here is the chart. So, $40,000 to $70,000, it starts at over $2,000. $100,000 to $1 million, it's $3,000 plus 3% of the state over $300,000. So for Bill and Mary's probate estate, when Bill dies, if that was going to probate and didn't just get passed to Mary, it would be $21,000 to file the probate for that. So not a good thing. And these fees are only for ordinary services. Anything that the lawyer does above and beyond, what the probate's needed, such as handling a will contest or dispute or giving tax advice, is deemed to justify a larger fee. So it adds up really quickly. It's very complicated, and you must hire somebody. Probate is exceptionally complicated. So even though families can handle it itself, a lot of times they'll hire an attorney anyways, and the fees can really vary in Massachusetts and Connecticut too. In Connecticut, the heirs can do the probate fairly easily because the process is fairly smooth, a little bit easier than, for example, New York or Massachusetts, where it's very formal and you have to have very specific forms that a lot of lay people can't find. Now, I'm not saying this to slam my colleagues in Polk County, and I'm not being over skeptical when I say this, but this is why some law firms can advertise really cheap wills, because they don't want to do the holistic estate planning and look at the big picture. They're expecting to get the probate fees for, servicing the will when you die. And that's quite the fact. It's considered a loss leader for many firms. And, it's not necessarily the best for anybody, but, people see, oh, it's $450 for a will in like the local Coffee Talk magazine. And they think that all attorneys should charge that, and they are getting nothing for their money in many cases. So, what about death taxes? I'm just going to go back to this for a sec. I'm not going to take a long time to talk about federal taxes, but, if you don't plan properly and you got a huge estate, well, over $11.7 million, you might have some federal tax issues. And, the thing with federal taxes, if you did have a big estate, or if the estate tax exemption comes down, like I discussed, the tax rate on estates are 40% of the excess of the exemption. So say you had $13 million, your 40% of the extra $1.3 million over your exemption would be a pretty big chunk of change that's not going to your heirs. And the state tax in each state varies. So, that's something to be worried about too, depending on the size of your estate. In Florida, there's no state tax, but there are in Massachusetts and Connecticut, like I explained before. And it's something that needs to be considered in your planning when you get up to those amounts over time. Now, if you're a couple, just to note that there is a marital deduction. So when a first person dies, there's federal tax exemption can get rolled over to the second spouse and won't get paid until the second spouse's death. So if you're in a situation where you're wondering if there is tax due, that is part of the consideration of when it's going to be paid, and are there ways to make sure that you're putting aside enough money to cover that tax so that you're not short when the time comes due to actually pay it. So a lot of people start distributing their assets to their heirs and don't realize they have to hold back money for those taxes. But let's not just focus on probate and taxes and nursing home costs. We want to make sure too, as part of estate family, that we preserve the wisdom and life stories that Bill left and had needed to hand down to his family and his grandchildren. Where's that preserved? It's really critical that the estate plan address that too. And, what we try to do is to work with clients to do documentation of some of that through journaling. And also we have services that are available for families if they'd like to do videos or audios. And we have a series of resources that really get people thinking about what could they do to pass on their memories. So let's pause for a moment and look how ineffective Bill and Mary's simple wills have been so far. They've not protected Bill from an expensive and lengthy conservatorship proceeding down at the court when he became disabled. And if he needed to go to a nursing home, there was no protection in the estate plan to protect any of his assets. So he had to pay for everything out of their pocket. They've not protected the family from any kind of death probate proceeding at death, and the kids had to go to court again. But most importantly, they've not provided any way for Bill's, to pass on his own personal legacy. And there's still three big worries after Bill is gone. Many clients are concerned that their spouse may end up getting remarried and the entire family's estate goes into the hands of strangers. So say Bill and Mary had $700,000 and Bill dies, Mary still has control of that $700,000 because the kids are both of their kids. But if Mary gets remarried, then what happens to it? It's not the end of the story. So let's look at what Mary's been up to since Bill died. Bill and Mary have been living next to Ralph for many years, and Ralph had lost his wife after a long stay in a nursing home, and he had spent all of his assets. So he's living, check to check for his Social Security. He's been coming over to comfort Mary, and they've had shared experiences in grief, and so they become very close. And, Mary's an attractive woman, but her money and her wealth and her lifestyle is very attractive too. So it's not long before Ralph, kind of moves in a little bit and says, why don't we share expenses? And doesn't it make sense that we live together? Mary, has never really managed a household on her own, and she's lonely, and she says, oh yeah, sure. It's very quick. And, the kids are a little concerned that Ralph might be trying to get at some of those assets and, buy himself a car or other things that, might affect their inheritance that their dad would have wanted them to have. We all kind of know stories like this. So, after courtship, he proposes to Mary. And, it's one of those things that blended families have to worry about. What happens when the spouse remarries? But you can prevent this from happening. You can actually protect the assets of a family by creating a trust, and it's pretty simple to set up. A well-drafted plan can absolutely seal up that gap and actually protect what was bills that Mary's holding in trust for the assets for the kids. We're going to talk about that a little bit in a minute. But it can protect the assets not only from Ralph, but from the prying reach of others. And it gives their surviving spouse a convenient excuse for, insisting on having some protection. And she might even suggest a prenup so that Ralph, agrees not to touch the trust and doesn't have any assets in it. If that's agreed in advance while Bill's still alive, that she has to have a prenup if she gets remarried, that's part of the estate plan. And then not her fault. It's not her saying that she distrusts Ralph. It's something that was built into the estate plan early on. So there's different tools that you can use that are pretty creative, that aren't all just about the money itself. It goes into the emotions and situations of the family. And what about liability? If Mary was driving along one day and hit a school bus and took her eyes off the road, what if there were some major injuries and Mary got sued? Well, she's holding on to a lot of the assets that Bill had. The creditors can certainly get to it. Unless she has some protection for that, again, liability could get eaten up by creditors and liens on that property from lawsuits. Is it important at all for you to have your spouse and your children protected from these kinds of risks? Now, let's go back to our story and find out how Mary's doing. Bill's passed away and Mary's the survivor. So as you remember, Mary, is holding herself now a full $700,000 when Bill passes. And, she's expecting to live about 14 more years on average, which is pretty good. But, she lives another 10 years. And what happens during those 10 years? Well, thanks to her wise investing, her assets have actually grown to $1.4 million in those 10 years. And you can ask yourself, well, isn't she spending any money? Why is it growing so fast? But really, the reverse is often true. If you have assets at that age and they're invested, you're taking down your 4% to be able to extend your savings. And actually, your savings still grow. They still accrue investments. And in a good market, you can have significant more assets at the end of the second spouse's life. In absence of, medical expenses, the estate will grow and will go to the children. But unfortunately, after surviving Bill for about 8 years, Mary develops Alzheimer's and is no longer able to handle her affairs. And so she's placed in a nursing home. So her costs accumulate, and she's got a memory care unit, which right now is running about $6,000. So she's faced with expenses of, let's say, $105,000 after being in the nursing home for about 18 months. The costs are paid directly out of the $700,000 savings that she has. And, that's a very common issue. But we do have now another living probate because she's got dementia. The kids are fighting over who's going to take care of her, because even though, Susan is a CPA and very financially responsible, and you'd think that she would want to be handling the affairs of her mom, John wants to get in on the action. He was very close to mom. He was maybe a mama's boy, and he wants to be involved. So that all goes to court because nobody's appointed somebody to take care of her. And the simple will, it was never decided. And there's another living probate with all the associated expenses. And when she does pass away, both are gone. And the estate at this point still can't just be distributed to the kids because, again, you have to go through the death probate process to change the title and all the assets. So they incur all the second round of death probate expenses. And again, here, she doesn't qualify perhaps for some, federal taxes, but because now she has 1.4 million, if she had been living in Massachusetts, she would have to worry about state tax. And so her will's, going to be wasting some money on the taxes that she's paying that she might not have had to if she had a different plan. So at the end of the day, if she has $1.4 million and her nursing home costs are 105, and the estate at the end of both deaths is about 13 million, the probate fees, if they probate in Florida, are going to be $35,000. That's a huge chunk of change just to go through probate to retitle assets. but it's mandatory. So the total costs incurred are $140,000, which maybe could have been saved by better planning. And the remainder in the estate is $1.26 million, which sounds great, but this causes some other worry because split two ways, each child gets $30,000, and what are they going to do with it? Once again, Mary's history has not been preserved, so it's certainly something that should have been considered for her as well. Now, when John and Susan each receive several $100s from Bill and Mary, it's a lifetime of their hard-earned wealth. And most clients kind of fear that their wealth is going to get misspent. It could be that their concern is to really make sure that their assets are protected for their children and grandchildren when they're gone. The top risks that parents actually really worry about with their children are divorce. One of their children will get divorced, and the ex will go away with half of whatever that child got in their inheritance, which happens all the time. Opportunists, people know that there is a child whose parents just died, and there are a lot of fraudsters trying to get to them because they know that they've just inherited a big chunk of money. There could be lawsuits and creditors now that know these folks have assets, and so they're more likely to sue or put liens on situations where there are debts or there's a lawsuit. People are going to ask for more money, but mostly, parents worry about misspending, particularly here, where we've got, a child that might actually have a drug and alcohol problem. So let's start with divorce protection. Here we see Susan's lazy husband, Jason. Bill and Mary never really liked him, even though they kind of put up with him. Despite the fact that they love their two grandchildren to death, they feel that Jason was bad news. He's always had a hard time holding down a job and has never been very ambitious. Susan's always been the one that was the breadwinner and supported the family, and he doesn't really help very much. So if Bill and Mary's estate plan called for an equal distribution of assets, and Susan gets $630, they're worried about that because if Susan wakes up and divorces Jason, he would probably get half if she put that money into a marital account and kept it as joint funds. A lot of the Susan's inheritance could walk away with Jason, and it's something that the parents wouldn't have wanted. There could have been ways that they protected that money to put it into Susan's own name so that it would have been protected for their grandchildren if Susan didn't need it. There was definitely better planning that could have been done. Now, we talked about divorce protection, but what about lawsuits and creditor claims? Well, here I talked a little bit about John being a walking liability, and maybe he would misspend it on alcohol and drugs, but maybe he's got a fast car and he'll get into a car accident really easily. Or maybe he's got a lot of debts and he hasn't paid his taxes for many years. If he's got a tax lien against him, then the government's going, woohoo, all this money that they can come get now. So, even though the parents want to make sure that he's protected against himself, there's nothing in place that's going to prevent him from taking that money and gambling it or, buying all his friends a big party and spending it down really quickly. And unfortunately, this happens a lot. And we might all know some people that this has happened to. It's very sad. And it's just a reality that, when you're giving somebody a big chunk of money, they might not know what to do with it. That's why lottery winners don't actually have a lot of money several years after they've won, and why a lot of kids with getting a full inheritance when they're young don't manage it well. So their plan really failed at almost every turn. They didn't have any nursing home protection, no protection against divorce of their daughter. The money could have gone to their son and been wasted, and that's just not taking control of their estate and their legacy the way that they would have wanted to. So at this point, we're going to switch around though and talk about the better alternative. We're going to talk about living trusts and why they're so popular, especially here in Florida where probate fees are really high. It's a document you may have heard of. It's also called a revocable living trust. We call it a family wealth trust because it's very comprehensive, but might not know how it works, or it's the first time you're hearing about it. It's really a will substitute, and it's got a ton of extra benefits and extra protection. For from a legal perspective, it distributes all your assets like a will does, but it also creates a mechanism where your affairs can get managed if you're disabled, both from a financial perspective, and also you can nominate somebody to have your personal care taken care of as well. It protects your estate if your spouse remarries and can keep your child's inheritance or grandchildren's inheritance safe in the event that they get into a divorce. The trust can dole out money over time and like a trickle. It can also shield assets from lawsuits and creditor claims if it's properly structured, because money in a trust is not an individual's personal money, and creditors not be able to get to it for many years until it's actually distributed to the beneficiary, and it's a way of holding money back and making sure that perhaps money goes to the next generation. This amazing document is really capable of doing a lot, which is why it's like the superpower in my Clark Kent and Superman example. So you just need to know how it works and make sure that you're really clear on what you want to put into it to make it really work well for you. So we're going to give Bill and Mary a do-over and see what their estate would have looked like if they had a trust instead of just a will. And, we really want to stress too that even with wills and trusts, they're fast food documents and they're good quality plans. For trusts, many of the older trusts were bare bones. There's some on the internet or people that are not experienced with it, just drafting kind of poor documents that really don't work. So you just want to make sure that all of the issues that we're addressing today are going to be discussed with your lawyer so that they can truly get to a family wealth portfolio that's going to be comprehensive and holistic. We want to make sure that it really solves your issues rather than creating more. And, you can buy your burger at McDonald's and you can buy your burger at Chris Steakhouse, and there's all kinds of flavors of trust, but you want to really make sure that you're just not pulling something up that is a cookie cutter will. So legacy wealth planning is what we're really talking about, though. It's a process used by a highly trained number of firms in the country, and it's endorsed by the American Academy, and it's really designed to protect the whole family, including, the family assets against lawsuits and creditors and divorce. Not only will it help when you're alive, but also can help for generations after your death. And it's made up of two components. It addresses all the financial issues that you've accumulated and also shields you from conservatorship, remarriage, probate, divorce, lawsuits, and creditors attaching your assets. It can also, in some cases, shield funds from nursing home or long-term care expenses. But also, personal items like family photos and memorabilia can be addressed in a trust or in lists of property that you designate. But more importantly, the legacy wealth planning system gives your family the means to capture your biographies, life stories, wisdom, and values for future generations, a number of tools that we've started talking about. So the entire process that we use, creates a full picture of what your wishes are and make sure that they're adhered to. So the magic of legacy wealth planning and living trusts are really how you hold title to the assets. Right now, Bill and Mary own assets in their own names, and a lot of you guys do too, or maybe you've put things in joint tenancy with your spouse. But really, a lot of the issues we've talked about today are triggered by a simple question. If something happens to Bill or Mary, how would we take control of their assets to carry out their wishes? If they're in the hospital and are incapacitated, then the title can't get transferred and you have to have the court come in. When Bill had a stroke, he couldn't sign papers or write checks or handle any financial affairs. So we needed a conservatorship in order to do anything for himself financially. So if they needed to sell the house in order to pay nursing home costs, it couldn't be done without going to court. The same thing happened when he died. And Mary died. They had to go back to court to be able to transfer the title of assets so that they could sell the property and distribute money to John and Susan. So that's what probate does. So all the court time and expense, really came out of the fact that the property is not held in Bill and Mary's name. And so what a trust does is change that. The trust is kind of like a magic box or a treasure chest. For many years, trusts of all kinds took property and held it for the beneficial use of others. And when we create the trust documents, it has nothing in it And then what happens is over time, you put your assets in it by retitling the deed while you're still capable of doing so. So instead of the house being in Bill and Mary's name, it'll be in, the Jones family trust name while they're still able to do that transfer and just move the deed over to the trust. And then what happens is when Bill and Mary die, it's not Bill and Mary that need to change the title on the property when it's sold, it's the trust, and the trust already exists. So I can't emphasize enough how important this mechanism is and what is needed for funding and making sure that property goes into the trust, because all the property that goes into the trust does not go through probate. There's already a title change that's already happened and it's not necessary. So it saves all of the time and expense of having to go through that court procedure early on. Now, you might be asking, if my assets are in the family wealth trust, who has the power to manage the property and pay the bills, and who pays for the insurance and things like that? Well, it's still your property. You can still do anything with it. The key is that there are 3 positions in every trust, and while you're still alive, you're going to fulfill all of them. So the first position is the role of the trustors. The trustors are the people that put the property into the box. So Bill and Mary were trustors. They transferred their property early on into the trust. Now we have the trustees. The trustees are the people who manage the buying, selling, and trading and exchanging the assets in the trust, the ones that sign and manage all the assets. Bill and Mary are going to name themselves as trustees, and so they'll be having complete control of their property still, even though it's in trust. All they do is sign, Bill on behalf of the Jones Trust instead of in his own name, and they still have complete control. They can buy and sell the property and use all the income from it. They're also the beneficiaries. Beneficiaries are people who have the right to spend money and use the assets in the trust. So while they're both living, they're filling all the roles, but so what would be the use of that? The use of that is really that they still have complete control over their assets when they are alive. However, and they can also actually amend it or change it and change any of the provisions of it. It's a revocable trust, so they also have the right to still cancel it or change any of its terms. But why they go through all the trouble is because it's a standby device. It's in place for when something happens. So if you become ill, disabled, or die, the person of your choosing is going to step in immediately as a successor trustee, and you don't have to go through court. So if Bill becomes disabled, then Mary becomes the trustee, and she can handle all the property without having to have a conservatorship. And then Susan could be named as the second successor trustee, so it automatically makes her responsible for managing the trust assets and helping with all that without having to be nominated a second time when Mary needs that care. There doesn't have to be any court involvement at all. But the trust doesn't operate just when you're alive. It spans several time periods. So let's look at the time periods that a trust can span. If this still applies if you're single, divorced, or widowed, you just have 2 periods instead of 3 periods, but it does still apply to multiple generations. So while Bill and Mary are still alive, we've got like our first phase, everything's fine. When Bill has a stroke, who has control of assets? They don't have to go to court to manage the assets because there's a family wealth trust and there's no living probate. So in phase 1, Mary gets named as the trustee, she steps in, she bypasses all the problems, and the magic happens. When Bill finally passes away, the family wealth trust will now be handed over to Mary, but without probate. She'll still have the ability to change title of assets because they're all in the trust name, and she can sign on behalf of the trust because she is now a trustee. There's no court fees, there's no public record, everything remains private, and the nosy neighbors can't find out that somebody's died and who's getting what, and creditors and scammers can't get the information. So it's all done seamlessly. And Bill's legacy, if he's written down his notes and his life story, can be preserved with that. Taxes would still be paid as they would be for an individual, but there are certain strategies that can be used for high income individuals to maximize the way that the trust works and the way that you can split a trust up to make sure that individuals get maximum tax deduction. So if they had won the lottery and had $20 million, each, and had a large estate, they could take advantage of the trust to do some planning there. So it's something to consider if you've got state taxes as well. And then remember, Ralph, he's still around consoling and wooing Mary. You can draft the family wealth trust in a way that if Mary decides to get remarried, we can protect Bill's portion of the estate from getting commingled with Ralph's funds so that he doesn't get any of Bill's wealth. And you can really design the family wealth trust to block any estate transfers outside of the family in a number of different ways. There's some nursing home expense and liability protection for Mary when she takes over phase 1 and she's managing the trust, because a portion of the estate can be protected from lawsuits. It's not distributed to Mary right away. She can hold on to it, and creditors can't get it when it's locked in that box. Now, you'll remember that several years after Bill died, Mary got Alzheimer's and had to go to a nursing home, and it was clear that her dementia prevented her from managing her own affairs. In the earlier situation, the family had to go to probate court and ask to manage the finances, but when the family wealth trust is in place, they've already designated Susan to manage their affairs. So again, there's no probate, and the cost to Mary's family to handle her affairs when she's disabled is nearly zero instead of almost $10,000. Now, it just so happens, along with their family wealth trust, Bill and Mary did some additional recommended planning and created a Medicaid protection trust, which is on top of the family wealth trust, but specifically dedicated to protecting assets in the event that you may need Medicaid services in the next 5 years or more. So that's going to be outside of this discussion, but that is also something where she may be able to save the family $105,000 by putting those assets in the trust, maybe for the grandkids, so it's not directly hers. You can preserve your family wealth for other people. Now, when Mary passes away, the estate doesn't go through probate, doesn't go through the death probate, because assets are not in Mary's name anymore. They're in the name of the trust. So they're just holding them for her, and you don't have to worry about retitling and everything. So there's a lot of protection that's built into this family wealth trust. And even in this first phase or this first stage when Bill and Mary are around, and a lot of people don't realize that trusts do all this or can do all of this, and that it is a holistic estate planning tool. Now, in that second phase, we had Mary with the trust. We're down to the third period for the family wealth trust when the kids get the estate. The third period when Bill and Mary are gone and the estate is ready for distribution to the kids. We know that clients have some serious concerns about giving money to the kids, and certainly Bill and Mary did about giving their kids the $630,000. But that can be all solved now, because instead of giving out the inheritance all at once, they can give it out over time. Now, when you squeeze a tube of toothpaste, you can't get the toothpaste back, and that's kind of how a trust often works. If you give money away too quickly or an inheritance too quickly, it's going to get spent and it's never going to get back, and you can't really protect anybody with it. But if you keep the trust together for some time, it can continue to manage the money while it's being given to Susan and John. So you can dole out a little bit at a time rather than having to put everything in one lump sum. And I apologize for all the noise. I can't get people to quiet down downstairs. So, but anyways, the way that they do that is they can have a family trust that is created that is split into two parts. John's share can go into a family century trust, which protects the money and only gives him a little bit of time as he needs it for his health, education, maintenance, and welfare. And maybe there's conditions on the fact that he might not get the lump sums or a significant amount of money until he's tested clean for drugs and alcohol, or it's only given on, the occasion of his marriage or the occasion of his having kids. So he doesn't have to get that money all at once. The same thing with Susan. She could have a family access trust instead of a century trust, and hers is going to be used a little bit differently because hers is to lock the money in her own name as inheritance money, so that it's not going to be deemed joint property of her and her husband, in the event of divorce. And so he won't necessarily get access to money that's in that trust for her. Now, she can still be the trustee of the family access trust and give herself money. She can withdraw it when she wants to, but if she wants to be careful and keep it in there, having a trust allows you those tools, and which is why we call it, having some superpowers. Susan has divorce protection, and her husband, could get nothing. So, we really want to make sure that we're not commingling assets in this situation, and a trust is the best tool for that. If Bill and Mary do a trust plan instead of a will, they will have accomplished all of their goals in a way that, they never would have thought was possible. So, as they say for John too, he could have life-changing incentives so that, maybe it's a carrot and a stick. It'll encourage him to get clean. And certainly, his parents would have wanted that for him. Now, also, if you have children with special needs, a special needs trust can also be created to protect child's inheritance and part of his money in a way that will not interfere with any federal or state benefits for the disability. And that's a whole special thing that, is outside the scope of this lecture, but it is possible also to do protection in that sort of situation as well. So now let's show you how our commitments get to put into action in our firm. We follow a 5-step legacy wealth planning system that provides a clear roadmap of each step along the way, from our first meeting until your plan documents have been signed, to the transfer of assets, and finally to a lifetime of communication and updates. We have kind of a system and a process that we're following that really makes sure that you are always on the cutting edge of estate planning strategies. First, we'll conduct your personal consultation virtually, either by phone or video, or in person if you're comfortable with that, at a number of locations. At that meeting, we want to have an open, honest conversation about everything that's important to you, what your concerns are, and we'll sit down with you and go over areas where you want protection. We'll talk about crazy family situations, and it's all confidential, and you don't have to worry about shocking me, because I've seen a lot already, and mostly happens in my family too. So we really want to ferret out what your situation is so that we can create a unique plan. Then we'll get to work on step 2, which is drafting all the documents that you'll need for the structure that you want. We'll schedule an asset inventory to make sure that we know exactly what assets are going to go into the trust, what might be exempt and don't have to go in a trust, and anything that might be able to be transferred outside the process altogether, like your life insurance. We'll make sure that we check the beneficiaries and know which bucket it's going into and whether or not it has to be protected in some way. So once the documents are ready, we're going to go to step 4, where you officially sign your plan and put your document in place and put your strategy in motion. You'll sign any asset transfer documents to retitle assets and change your deeds into the names that needs to go into, including any of your investments. We have investment letters that will get sent to your investment advisor, and make sure all your stocks and bonds and bank accounts get moved as they need to. Finally, we'll deliver your wealth planning portfolio in a signing ceremony, which will be very in-depth and make sure that you understand your plan with diagrams. In many cases, we'll be able to provide a video that educates not only you, but your family about how you structured your plan, why you did it, what the functions are, so that you can go back and review it over the years. And when your family, comes to the time where they have to administrate your estate, they'll be able to understand exactly what they're doing. And finally, in step 5, we continue to communicate and update and educate you periodically to make sure that we're proactive and checking to see if you've had changes. Maybe you have a new grandkid, or maybe you've moved again, or maybe you've sold a property that's no longer in the trust and you need to have things updated. So we'll make sure to be proactive and have a long-term relationship with you, not just throw you the documents and say, we'll see you when you die. We're just not about that. We want to make sure that it's holistic and that you're looking at all the various issues that come up in your life. So, we spent a lot of time educating you on the facts and the risks and the strategies to solve some of the concerns that you might have. And, where this all comes together is in our proprietary system and what we have as a legacy wealth planning portfolio. This is something that all of the American Academy of Estate Planning Attorneys provide their trust clients because it has been so valuable over the last 20 years. It's a big portfolio with all your documents and explanations of your documents, flow charts, transfer instructions, certified copy of your trust, locations of your assets, so you have that all written from your children, don't have to guess. They'll have, your healthcare directives and your healthcare proxies and your powers of attorney, as well as your personalized document video. And, if there's any confusion, we're here to answer any questions. We don't charge separately for phone calls, etc. The portfolio itself will have your family wealth trust and any sub-trusts that make up protection for assets or for spouses. And it'll have a pour-over will that takes in effect for any property that you did put into the trust for whatever reason, if that needs to go into a will process because the title hasn't been changed. There is a little emergency will that's included with that. But essentially, the key documents are your powers of attorney and all of those representative documents that'll help you if you're disabled or in the hospital. And then finally, we can assist you with creating a funeral trust or a cremation prepayment service that will save you a lot of money, time, and effort in making those decisions, when you're under stress or when your family's under stress, can really make your wishes known. So that's all part of the portfolio. If you do any kind of nursing home or Medicaid planning, that'll be in the binder as well, any of those documents. And, if you've got questions, again, we'll always be there to help you, but we're trying to put everything in one place to help you really see what you have and keep control. And you'll get also the documents on a scan disk so you can share that with your family as well as the video. So, what's the most important part of your planning? Well, it's whatever your wishes are. And again, we don't want to be using just a cookie cutter document because it's not going to address those concerns if things aren't properly funded in your trust or the documents aren't properly managed. You really want your attorney to get into all of these issues and not just, say, oh yeah, you're fine with a will, without really digging in and asking the right questions. And again, you want to make sure that your law firm is helping you with the funding, because a lot of times attorneys just give you the documents to do it yourself and aren't assisting with the real estate transfer. People procrastinate and it doesn't get done. And then again, trust is just an empty shell that's not working. So, we've gotten to the point where we've talked about our process. We've talked about what you get for the process. And, let's talk a little bit about pricing and fee expectations, because as I say, what you're paying for is not the documents, which, print out and aren't really necessarily expensive in themselves to print out. You need specialized software and you need specialized experience, but what you're really paying for is the guidance and counseling and the strategies that will accomplish your goals, and not just assuming that, a will is going to take care of your problems if you're concerned about probate and protecting your family. You really want to work with a firm who asks good questions and an attorney that you're going to be comfortable with, because this is a long-term process and it's something that is going to be in effect over years, potentially generations. And a lot of times, if you die 10, 15 years ago, then you want to be able to have records and make sure that you've had enough understanding about what's been happening so that your children will be able to step in without fighting and having any confusion. Most importantly, you don't want to be able to pay hourly fees, because for estate planning, you do not want surprises. It can add up really quickly if you're paying on an hourly basis for the consultation and all of the different work that needs to be done. If somebody has to run around and find out, where you have investments or other types of questions, it just adds up quick. So most of the estate planners, even in Polk County, do things on a flat fee basis. And, it's soup to nuts. I think my rates are probably, average. They're not the lowest, they're not the highest. We've done a lot of research to make sure that they're consistent and fair as for our market. And with the backing of the American Academy of Estate Planning Attorneys, all of their attorneys nationwide report their fees. So that you're getting something that you're not getting ripped off at, that we're giving you a value that other clients are finding is super helpful. And particularly when you think about probate, just being in Bill and Mary's case, at least $21,000 and more like $35,000 when Mary buys, it's something that the cost of a trust is way cheaper than ever going through those kinds of expenses. So for us, we don't like unpleasant surprises either, especially when it comes to lawyer fees, even though I am a lawyer. So, before we begin, we want our clients to know exactly what they're going to pay. And just to give you an example, our family wealth trust will cost a certain amount. We tell you what it is up front, and we will help you decide whether or not you want a trust or a will. We'll give you the pros and cons, and you'll ultimately make that decision. Maybe you don't need a trust right now, and maybe that's the right thing for your family. But if you do, either direction, you're going to know up front, and it's going to be a flat fee. So I'd also charge flat fee for wills and other work that we're doing. But because most people really like the idea of the family basic wealth trust and they want the protections if they can have it now that they know about it, we put together a package where you have the family wealth trust. It's got incapacity protection, probate and tax protection, that divorce and remarriage protection, and creditor protection kind of wrapped in. And it has a lot of benefits for an individual. It's $3,299. For a couple, it's $3,999. It's my pricing. And then if you want that special protection for the Century Trust or asset protection against, the children's divorce and remarriage, because you have to set up different trusts and paperwork and fund that as well in a certain way. That's a little bit more. They're going to be $500 each, but that's it. We don't charge for copies. We don't charge for calls. And then, our firm includes a lot of other information that other firms don't in the package as part of the holistic plan. So not only we do have the wealth planning and trust workbook or the portfolio in a single place, we include the deed transfer to make sure that you're funding that trust and you're not holding off and procrastinating on that. We also include 3 years of DocuBank membership, which is a service that holds your healthcare directives and your important documents in the cloud. So if you're in the hospital and your kids don't know where your healthcare directive is, or they need medical records quickly and you need a HIPAA release and they can't find it in the house or they don't have immediate access to it, they can call DocuBank, carry a little card in your wallet, and either call or go on the internet and request those documents. And DocuBank's open 24/7. They will ship those copies of the documents to your medical providers, the hospital, your doctors, and it's really super helpful in an emergency. It's even great for people that have kids in college and then they're worried about, the kids not having the access to the parents, something happens to them. The DocuBank service is really valuable, and we cover the first 3 years with the trust, and then you can renew it yourself over time, and we'll send you reminders and everything, but it's a really nice benefit that we'll have going forward. Also, you do get the video consultation that you can share with your family, and up to 2 hours of consultation with your tax advisors and financial planners to really coordinate plans to make sure that you've got the life insurance there. And just, generally I keep a list of, I got a guy, if you need painting, decorating, redecorating your house, making sure somebody has, the ability to go in and do your estate sale, all of that I'm collecting over time so that we can have the resources for families that, other people might not just have as far as a huge network. I'm now engaged with the Better Living for Seniors Chamber of Commerce for elder care here in Polk County, the Winter Haven Chamber of Commerce, and other organizations where we've just got networks of guardians and home care people and, incredible resources that are just invaluable and are pretty much worth more than your trust, because you can have reliable, well-tested people that kind of been vetted by the firm. And you'll have a flash drive with electronic copies of your documents, as well as helpful advice for future trust administration for your heirs when the time comes. Another thing I just want to note, that one of the things I'm going to be doing, I should call it Tara's mom's plan or Tara's plan, is we're offering what I call a foundation services that's unique to the firm, and because there's just such a need for it. It's personalized time up to 4 hours in your home or your dedicated location to sort, organize, and review all your financial documents and paperwork, which might be piled in drawers, in buckets, wherever it is. we'll get you organized, we'll figure out what your assets and liabilities are, we'll do a budget for you if you want that degree of planning. And really, we'll go through the documents, we'll shred anything that's going to be outdated or old, and you have questions on things like an insurance policy, you don't know if it's still valid, we'll make a call for you. This is something that a lot of times the first spouse passes and they've done the checkbook and they've done all the accounting, and the second spouse doesn't even know how to pick up a phone. And you need a daughter, a family member to come down and do it. But a lot of times people don't have their family members here to be able to help with that. And if my mom's on the phone, I'm so sorry, because I usually do this for you at home. I'll fly up and do this for you too. But, we want to make sure that as a foundation of whether to get a will or a trust, that you have all of your documents looked at and you have a list of assets and you understand what you have and what to do with it. And if you're being overcharged, if you don't know, if something's good or not. A lot of times people have their life insurance reviewed and they've got tons of life insurance that they're paying for that they don't need anymore because they're like 80 years old and it's not income protection anymore, and their kids don't need to inherit $1 million. So why are they paying $1,000 a month for it? So things like that, we can do it with like a little bit of a financial review and just have a second set of eyes on that. We could help you with a fireproof vault or security box. That's something that we can get for you if you haven't thought of buying one, and that's additional. But we do this for $799. And if you get like a full trust, we can sometimes take some money off of that, because then your assets go into the trust and it's a little bit easier for there. So now the program's over. I wanted to thank you for staying with me for this time. I'm probably about 7 minutes over right now, and I'm sorry to have talked too much, but it's good for me to practice the timing here and to get that cut down. You can certainly give me comments. I want to make sure that we've addressed everything that's important to you and that you've gotten some education on really what to expect. If you would like to have a consultation, you're my friends and family, but I am actually offering for anybody that does this seminar a free consultation gift certificate, provided that the appointment is actually scheduled in the next 2 to 3 weeks, that both spouses must attend, so that decision makers are there. If you have a partner or you've got a kid that's participating in your decisions, they should be there too. And at that time, we'll go through your situation. I'll ask a bunch of questions. You'll ask me a bunch of questions. We spend at least an hour together to really hone your situation. And at the end of the appointment, I'll say, do you want to continue or not? And if you say yes, we'll get started. No procrastination. If you say no, no is okay. We want to make sure that you're totally comfortable with every step in the process. We'll sign an engagement agreement based on the agreed fees for the services that you want, and we'll move forward. But that consultation is very valuable, and it's something that you can really start thinking about this with an independent person. And sometimes it gets really interesting conversations with the spouse when you do that. So you can book your consultation by calling me, emailing me, and if you don't reach me immediately, I'll call you back within 24 hours and we'll get that scheduled, testing Calendly and everything as well. So you might get a Calendly invitation to pick a time. But I really wanted to thank you for your time. Thank you for staying over with me. I hadn't been as mindful in the past as the time, and I really apologize for that. So that is something that I'm giving myself on feedback form to be more attentive to. But look for a survey with me, sending it from my work email in the next day, so that you can rank me in the seminar and talk about anything that you thought was good or bad in the seminar and where we can do better, because that'll help me when I go out into the big wide world of the public, get my act together. So again, thank you so much. Any questions that you have, just shoot them over. Thank you, and we'll talk to you soon. Bye.